They laughed when I walked into that courtroom, not out loud. They were too polished for that. But I saw it. Diane, my own daughter, sitting at the plaintiff's table in her black Chanel suit, her lips pressing together in that particular way she had when she was trying not to smile. Brandon beside her, nudging his attorney with one elbow, leaning over to whisper something. The attorney, Paul Donovan, 62 years old, 24 years in elder law, winner of 80% of his competency cases, glanced at me and looked away just as quickly, the way people look away from something they don't consider worth their attention. I shuffled in with my old brown handbag and my sensible shoes. My navy dress was the one I'd worn to George's company Christmas parties back in the 90s. My silver hair was pinned back neatly, the way I'd worn it every Sunday to church for 30 years. I looked exactly like what they expected me to be. A confused old woman who had no business being in a courtroom. The bailiff, a broad-shouldered young man named Tom Reardon, held the gate open for me with a kind expression, the kind people reserve for the elderly and the lost. I thanked him quietly and made my way to the defendant's table. Sat down alone. No attorney beside me. No briefcase full of documents. Just the handbag, set carefully on the floor beside my chair. Diane whispered something to Brandon. He nodded, smiling. I folded my hands on the table and waited. 6 months earlier, I had been holding George's hand when he died. The hospital room smelled of antiseptic and cut flowers. Ruth had brought tulips, yellow ones, George's favorite. The monitors had been beeping steadily for 3 days, and then at 4:17 in the morning on a Tuesday in February, they simply stopped. The doctors had given us 6 months. George had made it 4. Cancer, as I had come to understand it, does not negotiate. Ellie. His voice had been barely a breath by then, rough as dry paper. I leaned close. They're going to come for you. George, let me finish. His hand tightened on mine, surprising strength for a man who hadn't eaten in 4 days. They think you don't know anything. Let them keep thinking that. Everything is in place. I made sure. He paused, gathering himself. The envelope, in the second drawer of my desk. Don't open it until after the reading. You're being dramatic, I told him, because that was how we talked to each other after 41 years of marriage. Honestly, without cushioning, he almost smiled. Promise me, Ellie. I promise. He died 40 minutes later, and I sat beside him until the sun came up over the Boston skyline, watching the light change from gray to pink to gold, thinking about 41 years of morning coffee and quiet arguments, and Sunday crossword puzzles, and the specific, irreplaceable weight of someone else's hand in yours. The envelope stayed in the drawer, unopened, for 2 weeks. Harold Fitch had been George's attorney for 22 years. His office on Boylston Street smelled of old leather and wood polish, the kind of smell that says serious money has been discussed in this room. He was a careful, deliberate man who wore bow ties and spoke in complete sentences, and on the afternoon of February 28th, he read George's will in a voice that was professionally devoid of expression. Diane had dressed in full mourning. Black dress, black heels, a small clutch that cost more than most people's car payments. She held a folded handkerchief in her right hand. Not because she'd been crying, I noticed, but because it looked appropriate. Brandon sat beside her in a charcoal suit, one ankle crossed over his knee, his eyes moving slowly around the room in a way that reminded me of someone taking inventory. I wore a gray cardigan and George's favorite pearl earrings. To my beloved wife, Eleanor Ann Whitfield, Harold read, I leave the entirety of my estate, including all properties, business holdings, investment accounts, and liquid assets currently valued at approximately $58 million. The silence that followed was the loudest thing I had ever heard. Diane's handkerchief fell to the floor. That's not possible. Her voice was very controlled, which told me she was very close to losing control. Dad promised me the Newport house. He told me, to my daughter, Diane Whitfield Hargrove, Harold continued, with the practiced calm of a man who had delivered unwelcome news before, I leave my collection of first edition American literature and the photograph from our trip to Yellowstone in 2003. A photograph. Brandon's voice was flat, stripped of its usual easy confidence. He left her a photograph. To my son-in-law, Brandon Hargrove, I leave my set of Wilson golf clubs, which he admired on several occasions. Brandon stood up. There has to be a mistake. This has to be a mistake. He looked at me for the first time. Really looked at me. And I saw something move behind his eyes. Not grief. Calculation. Eleanor, you had to have known about this. You must have... Did you influence him? Toward the end, when he wasn't himself? George was entirely himself until the very last day, I said quietly. You would know that if you'd visited more. The drive home was long. I made tea when I got back, sat in George's armchair, and let myself feel for exactly 1 hour the full weight of everything. The grief, the exhaustion, the particular ache of being widowed at 67 in a house that still smelled like someone else's life. Then I got up, went to the study, and opened the second drawer of George's desk. The envelope contained 2 things: a business card, crisp and white, the Honorable Susan M. Calloway, Superior Court Judge, District of Columbia Circuit, a handwritten phone number on the back, and a note in George's handwriting. Small, precise, the way he wrote everything. Ellie, call Susan Calloway. She remembers you. Trust her. And check the second shelf of the law cabinet. I've been keeping it current. I stood in the study for a long time, holding that note. Then I looked at the cabinet in the corner, the tall mahogany one I'd always thought held George's business files. I opened it. 17 years of updated legal journals, current case law annotations, Federal Rules of Evidence, 2024 edition, annotated copies of every significant elder law ruling in Massachusetts and D.C. from the past decade. George had been maintaining my library for 17 years without ever saying a word. I sat down on the floor of that study, right there on the Persian rug he'd bought in Istanbul in 1998, and I cried for the second time since he died. Not from grief this time, from the particular devastating love of being truly, completely known by another person. The lawsuit arrived on a Tuesday, delivered by a young man in a brown uniform who couldn't quite meet my eyes. The paperwork was thorough. Paul Donovan was good at his job. I'd give him that. 4 inches of carefully organized accusations, tabbed and indexed. According to these documents, I was suffering from progressive cognitive decline. I had been manipulated by unknown parties into believing I was the rightful heir to George's estate. I posed a significant risk to myself through irrational financial decision-making. I required immediate court-appointed conservatorship for my own protection. The evidence they'd assembled was, I had to admit, creative. There was the incident documented by Brandon where I had asked our 14-year-old granddaughter, Sophie, to help me set up a new streaming application on my tablet. Inability to manage basic technology. Concerning indicator of cognitive regression. There was the Tuesday last October when I'd gotten turned around driving to Diane's house because of unexpected road construction on Route 9 and arrived 40 minutes late. Disorientation and spatial confusion consistent with early-stage dementia. There was Brandon's sworn affidavit, 3 pages, single-spaced, describing how I had become increasingly paranoid and secretive about financial matters, refusing all reasonable guidance from family members who have only her best interests at heart. I read all of it while my coffee went cold. Then I read it again. My phone rang at 11:15. Diane. Mom. Her voice was soft, careful, the voice she used when she wanted something. I'm so sorry you had to find out this way. We tried to talk to you about this privately, but you just wouldn't. You tried to talk to me about having me declared mentally incompetent? A pause. We tried to talk to you about getting some help, about making sure you're protected. I see. The good news is, once the court puts the right safeguards in place, you won't have to worry about any of those complicated decisions anymore. The investments, the properties, Michael and I can take care of all of it. I watched a cardinal land on the bird feeder outside the kitchen window. George had hung that feeder the spring before he got sick. He'd called cardinals little messengers. And where would I live? I asked. During these arrangements. A brief pause. Rehearsed? I thought. Everything's about this call was rehearsed. Well, the Newport cottage would be perfect for you. It's manageable, comfortable. You wouldn't have to worry about maintaining a big property. Brandon and I would take the main house, of course, since we have more family obligations. Of course they would. Diane, I said, do you genuinely believe I'm mentally incompetent? Mom, it's not about belief. It's about reality. You married Dad when you were 26. You've never had a career. You don't understand finance or legal matters or... Thank you, I said. That's very helpful. I hung up, sat for a while in the quiet kitchen. Then I went back to George's study, opened the mahogany cabinet, and took down the top volume from the second shelf. Federal Rules of Evidence, 2024, annotated. I made a fresh pot of coffee, pulled out a yellow legal pad, and began to write. 3 days before the first court appearance, I drove to Diane and Brandon's house in Wellesley. I hadn't called ahead. I parked in the circular driveway behind Brandon's new Porsche, the one George and I had declined to co-sign a loan for 2 years ago, the one Brandon had financed through other means I'd never asked about, and rang the bell. Diane opened the door in yoga clothes, fresh from the gym, and her surprise was not entirely welcoming. "Mom, I wasn't expecting—" "I know. May I come in?" The living room had been redecorated since George's funeral. New sectional sofa in pale gray linen. A large abstract canvas above the fireplace that I recognized as the kind sold in galleries that primarily cater to people with more money than patience for actual art. Fresh flowers on the coffee table, lilies, their smell heavy in the closed room. All of it purchased, I knew from Harold Fitch's records, in the 18 months before George died, during the period when Diane had been certain of what was coming to her. Brandon was, Diane told me, at the office. Good. I sat down, accepted the coffee she offered out of muscle memory rather than genuine hospitality, and looked at my daughter across the glass coffee table. "Diane, I want to ask you something directly, before this goes any further." She sat with her mug held in both hands, her expression carefully arranged into concern. "Of course, Mom. What if I told you I've been pretending?" A small crease appeared between her brows. "Pretending what?" "Pretending to be confused. Pretending to need help with things I understand perfectly well." I watched her face. "I asked Sophie about the streaming app because I wanted to see how you'd all react. I already knew how to use it. I've had a Netflix account since 2017. The crease deepened. "Mom, that doesn't—" "People tell you things when they think you're not a threat," I said. "They say things in front of you. They make plans. They stop being careful." I set down my coffee cup. "And you learn a great deal." For just a moment, one unguarded second, something flickered in Diane's expression. Not quite fear, something closer to the look a chess player gets when they realize they've been seeing a completely different board than their opponent. Then she shook her head, and the concern came back. "Mom, this is exactly what I mean. This kind of paranoid, conspiratorial thinking. Is that what it is?" I stood, smoothed my skirt. "I suppose we'll find out." I moved toward the front door, paused with my hand on the brass handle. A handle George and I had helped them pick out when they'd bought this house 7 years ago. We'd co-signed that loan too, $214,000 across 7 years in what Diane had always called borrowing, and what I had come to understand was something else entirely. "Diane." I turned back one last time. She was standing in the middle of her expensive living room, coffee mug in both hands, looking at me with an expression I hadn't seen on her face since she was 16 years old and had just realized she'd underestimated a situation. "I love you. I've loved you since the moment you existed. But I need you to understand something. Mom, your father worked for 40 years to build something, and I stood beside him for every single one of those years. Not in the background, not as decoration, but as his partner. In every way that mattered." I held her gaze. "You have made a very serious miscalculation about who you are dealing with." I left before she could answer. Driving home, I felt something I hadn't felt in a very long time. Not the comfortable numbness of grief, not the low-grade anxiety of the past 6 months. Something older, sharper, like a muscle remembering how it used to move. I had a case to prepare. That evening, I sat in George's armchair with the business card in my hand for a long time before I dialed. The number rang twice. "Judge Calloway's chambers." A young woman's voice, professional. "This is Eleanor Whitfield. I'd like to speak with Susan about a matter coming before her court." A pause, longer than a standard hold. Then, "Eleanor Whitfield. As in Eleanor Mackenzie Whitfield?" "Yes. Please hold." I listened to 30 seconds of silence. Then the line clicked, and a voice came through that I hadn't heard in 35 years. A voice that was older now, lower, but with the same precise diction and the same quick energy underneath it. "Ellie, my God," I exhaled. "Hello, Susan. I looked at the docket this afternoon and I saw Hargrove versus Whitfield, and I thought, no, it couldn't be." A pause. Your daughter is suing you. She is. For mental incompetence. That's the allegation, yes. Susan Odell had been 2 years ahead of me at Georgetown Law School, class of 1979 to my 1981, though we'd overlapped for 2 years in the moot court program. She'd been the most formidable appellate advocate I'd ever seen, and I'd seen her dismantle a federal prosecutor's case over the course of a single afternoon with nothing but a yellow legal pad and 30 years of case law in her head. She'd been Susan Odell then. She was Susan Calloway now, and she had been a Superior Court judge for 14 years. George had always been thorough. Eleanor the Blade Mackenzie, Susan said, and I heard the precise moment she decided to find this funny rather than alarming. Mentally incompetent. I've been on the bench for 14 years, and I don't think I've ever... She stopped. Tell me you're not walking into my courtroom without representation. I'm keeping my own counsel. Ellie, you've been out of practice for 30 years. Paul Donovan is good. I know. I've reviewed his last 40 cases. I reached down and pulled the yellow legal pad from beside the chair. 12 pages of handwritten notes, both sides. He has a pattern. He relies heavily on behavioral testimony in the opening petition, then pivots to medical evidence once the defendant is already rattled. He counts on the defendant being too overwhelmed to challenge his procedural moves early. I paused. He also filed an incomplete discovery package. He's missing 3 years of financial records that he would need to support the asset mismanagement claim. A long silence. You've already been preparing. George left me everything I needed. My voice held, though just barely. He's been maintaining my legal library for 17 years without telling me. Every update, every new edition, every relevant case annotation. I looked at George's photograph on the mantel, the one from our 30th anniversary, the two of us on the deck of a rented sailboat off the coast of Maine, both of us laughing at something the photographer had said. He knew this day would come. He made sure I'd be ready. Susan was quiet for a moment. Do you remember what Professor Hartley used to say? First day of evidence? I smiled. Never let them see you coming. Exactly. Another pause. Eleanor, I have to ask you directly. Given our history, given that we know each other, can I ethically hear this case? We were colleagues, not close friends. It's been 35 years, and our past association has no bearing on the evidence. I turned the legal pad to a fresh page. But Susan, I need you to let it play out. Don't tip your hand early. Let Donovan make his full argument before you intervene. You want them to believe they're winning. I need them to believe they're winning, right up until the moment they aren't. Another silence. Then Susan Calloway, Superior Court judge, made a sound that I recognized after 35 years without any difficulty at all. She was laughing. God help Paul Donovan, she said. He has no idea what's about to walk into his courtroom. After we hung up, I sat in the quiet study for a long time. Outside, the last of the winter light was fading over the backyard, and the bird feeder cast a long shadow across the snow. No cardinals tonight. I opened the mahogany cabinet, took out the annotated copy of Massachusetts Elder Law Practice, 2023 edition, set it on the desk beside the yellow legal pad. Then I reached to the very back of the bottom shelf, behind the journals, behind the case files, and found what George had placed there last, sometime in his final months, a small digital recorder, compact and modern, still in its original packaging, and beneath it, a folded note, the living room corner, left of the fireplace. The acoustics are good there. Just in case, Ellie, just in case. I held the recorder in both hands and thought about 41 years of a man who had loved me so completely, so practically, so quietly. A man who had never once doubted what I was capable of, even when I had spent 30 years pretending otherwise. Okay, George, I said to the empty room. Let's go to court. I set the recorder on the desk, opened my legal pad to a fresh page. At the top, I wrote 3 words. Defense strategy, complete. And I began. Ruth Langley was standing at my front gate at 7:15 in the morning, holding a covered dish and wearing the expression of someone attending a funeral. Ellie, I made you a casserole. Ruth, the hearing is at 9 o'clock, not my burial. You're going into a courtroom alone against 2 lawyers and your own daughter. She thrust the dish at me. You need casserole. I took it, set it inside, and came back to find her still at the gate, wringing her hands in a way that reminded me of a character in a Victorian novel awaiting bad news. "Are you absolutely certain you don't want to call someone? A real—" She caught herself. "I mean, a practicing attorney?" I picked up my handbag from the porch table. The brown one, old and soft with use, the one Diane had once called embarrassing at a charity luncheon. I smoothed my navy dress, checked that George's pearl earrings were fastened, and looked at my neighbor of 22 years. "Ruth," I said, "I am a real attorney." She stared at me. I kissed her on the cheek, walked to my car, and drove to the Suffolk County Courthouse without looking back. The morning light was sharp and cold, the kind of February clarity that makes Boston look like a city carved from glass. I arrived 20 minutes early, found the correct courtroom on the 4th floor, and sat alone at the defendant's table with my old handbag on the floor beside me. Diane and Brandon arrived at 8:52 with Paul Donovan and a younger associate whose name I didn't catch. They were talking easily among themselves, Donovan making some point with his hands, Brandon nodding in that decisive way he had when he wanted to appear more certain than he was. Diane looked rested. Her suit was charcoal today, her hair blown out, small diamond earrings that George had given her for her 30th birthday, catching the courtroom light. She glanced at me when they came in. Something moved across her face. Not quite guilt, not quite triumph. Something uncomfortable that lived between the two. Then Donovan said something and she turned away. Brandon didn't glance at me at all. Bailiff Tom Reardon called the room to order at precisely 9 o'clock. The door to the judge's chamber opened. Judge Susan Calloway walked in. She was 63 years old, silver-haired, with the erect posture of someone who had spent decades being the most authoritative person in every room she entered. She wore her robes with the ease of long habit. Her eyes swept the courtroom in the practiced, encompassing way of an experienced judge. And for exactly 1/2 second, when those eyes found me at the defendant's table, her steps carried the faintest hesitation. No one noticed. Donovan was arranging his papers. Brandon was straightening his tie. Diane was uncapping a pen. Susan Calloway took her seat, looked down at her docket, looked up. "We're here on the matter of Hargrove versus Whitfield," she said. "Petition for determination of mental incapacity and appointment of conservator. Mr. Donovan, you represent the petitioners?" "Yes, Your Honor." "And Mrs. Whitfield, you're representing yourself in this matter?" I stood slowly, let my hand rest on the table as though I needed the support. "Yes, Your Honor, I couldn't afford an attorney." At the plaintiff's table, Brandon leaned toward Donovan and said something behind his hand. Donovan's expression remained professionally neutral, but his eyes carried the particular quality of a man who has just been told that this will be easier than expected. Paul Donovan was good. I had studied 40 of his cases, and I knew exactly how good he was, which made it almost comfortable in a strange way to watch him work. He built his opening argument the way a skilled carpenter builds a cabinet, methodically, solidly, one piece fitting into the next with practiced precision. He painted me in careful strokes. A woman of limited education who had never worked outside the home. A devoted wife whose entire understanding of the world had been filtered through her husband's management of it. A grieving widow, vulnerable and disoriented, who had somehow, through means the petition would make clear, come to possess an inheritance wildly disproportionate to her capacity to manage it. "The petitioners are not here out of malice," Donovan told the court, his voice carrying the measured gravity of a man speaking difficult truths. "They are here out of love, out of legitimate concern for a woman who, by her own family's testimony, has demonstrated a consistent and troubling pattern of confusion, dependency, and inability to comprehend even basic financial matters." He cited the Netflix incident, the wrong turn on Route 9, Brandon's affidavit about my paranoid secretiveness. I sat with my hands folded and let him finish. "The petitioners request an immediate competency evaluation and temporary conservatorship," Donovan concluded, "to protect Mrs. Whitfield's assets from further mismanagement and to ensure her safety and well-being going forward." Judge Calloway looked at me. "Mrs. Whitfield, you may respond." I stood, slowly, both hands on the table, let the silence settle for exactly 3 seconds. "Mr. Donovan," I said, "you've alleged that my husband's will was the product of manipulation by unknown parties. The will was witnessed by 3 individuals and notarized by Harold Fitch, who has been a licensed notary in the Commonwealth of Massachusetts for 28 years. I paused. "Are you alleging that Mr. Fitch and the 3 witnesses were also manipulated?" Donovan's expression didn't change, but something behind his eyes did. Your Honor, the petitioners don't allege specific misconduct by the notary. The manipulation, then by whom? I asked pleasantly. You keep referencing these unknown parties. In 4 inches of legal filings, you haven't named a single one. Your Honor, Donovan turned to the bench. Mrs. Whitfield clearly lacks the legal background to understand the Massachusetts General Law. Chapter 190B, I said, requires clear and convincing evidence of incapacity, not behavioral anecdotes, not family testimony from individuals who stand to inherit, not a sworn affidavit from a son-in-law who has borrowed $214,000 from the alleged incompetent over the past 7 years. The courtroom went very quiet. Donovan stared at me. Brandon had gone still. Diane was looking at me with an expression I hadn't seen on her face in 30 years. The expression of a child who has just discovered that the adult in the room knows considerably more than they let on. Your Honor, Donovan said, and his voice had lost some of its easy authority. Mrs. Whitfield is clearly being coached by someone. No layperson could— By whom, Mr. Donovan? Judge Calloway's voice was perfectly level. She's representing herself. I straightened my shoulders. It was a small movement, barely perceptible, but something in it changed the quality of the air in the room. 30 years of careful performance, the soft voice, the uncertain hands, the navigating by instinct posture of a woman who needed help finding her way, fell away like a coat I'd been wearing too long. Your Honor, I said, I'd like to present my credentials to the court. I opened my handbag. Reached past the reading glasses and the folded handkerchief and the small bottle of hand lotion, took out a card, set it on the clerk's table. Eleanor Ann Mackenzie Whitfield, member of the District of Columbia Bar Association since 1981, license number 612847. I looked up. Current and active. The silence had a different quality now. Tom Reardon, the bailiff, blinked. The court reporter's fingers stopped moving on her keyboard. At the plaintiff's table, Brandon's mouth opened and then closed without producing any sound, and Donovan was looking at the card on the clerk's table with the specific expression of a man watching a ship he is aboard begin to sink. Diane had gone perfectly still. Her pen was still in her hand, uncapped, but she had stopped writing. She was staring at me, not with calculation now, not with the careful management of expression she'd been wearing all morning, but with something raw and unguarded that I recognized, despite everything, as her real face. I practiced criminal defense law for 17 years, I continued. At Mackenzie & Associates in Washington, D.C., I specialized in complex fraud, financial crime, and estate disputes. I maintained an undefeated case record across those 17 years. I paused. I retired voluntarily in 1988 to raise my daughter, the same daughter who is currently suing me for mental incompetence. Judge Calloway examined my credentials with an expression of careful neutrality. Around her eyes, if you knew where to look, there was something that might have been satisfaction. Mrs. Whitfield, she said, why didn't you disclose your legal background at the outset of these proceedings? Because, Your Honor, I wanted to see the full extent of the accusations Mr. Donovan would make against someone he assumed was legally ignorant. I turned to face Donovan directly. You've spent 20 minutes arguing that a woman who asked her granddaughter about a streaming application lacks the mental capacity to manage a significant estate. You didn't research me. You filed a petition alleging incompetence against a licensed attorney without performing a basic background check. Donovan found his voice. It was shakier than before. Your Honor, this changes nothing. Mrs. Whitfield hasn't practiced in decades. The evidence of recent decline is what, precisely? I asked. That I got lost during road construction? Mr. Donovan, if spatial disorientation during unannounced highway detours constitutes dementia, I would gently suggest reviewing your own GPS history before drawing conclusions. A sound moved through the courtroom. Not quite laughter, something more restrained, quickly suppressed. Judge Calloway's gavel came down once, lightly, less a call to order than punctuation. Mr. Donovan, do you have any medical evidence? Any neurological evaluation? Any psychiatric assessment? Any documented diagnosis from a licensed physician supporting your claim of mental incapacity? Donovan shuffled his papers. We request that the court order a full neurological evaluation. Based on what medical grounds? Based on behavioral observations from family members who... family members who stand to inherit $58 million. The quiet that followed was the kind that fills a room and stays. During the recess, I stood by the window at the end of the fourth-floor hallway and watched the city below. February traffic, a food cart on the corner, two pigeons arguing over something near a trash can. Donovan approached me from down the hall, his earlier confidence replaced by something more careful. "Mrs. Whitfield, my clients are prepared to discuss a settlement. Withdraw the conservatorship petition in exchange for a more equitable division of the estate. You mean Diane would like her inheritance after all? $58 million is a substantial sum for a single individual to— Are you questioning my mental capacity again, Mr. Donovan? Because I should mention that didn't end particularly well for you the first time." He left. I watched through the glass doors as he rejoined Diane and Brandon. Brandon was on his phone, pacing, his free hand moving with sharp, cutting gestures. Diane stood slightly apart from him, her arms crossed, looking at the floor. When court reconvened, there was a new attorney at the plaintiff's table. He had appeared during the recess, young, aggressive-looking, with the kind of contained intensity that suggested he'd been called in as an emergency measure. His name, I would learn in the next 5 minutes, was Derek Stafford, and he had a different strategy entirely. "Your Honor, the petitioners are amending their claim." He was on his feet before Calloway had fully settled. "We now allege that Mrs. Whitfield deliberately deceived her family regarding her mental and professional status, manufacturing a scenario designed to entrap the petitioners into filing this lawsuit. This pattern of calculated deception is itself evidence of a dangerous psychological disconnect. It was, I had to admit, clever. Instead of she's too incompetent to manage her affairs, which I had just demolished, they had pivoted to she's too manipulative to be trusted with her affairs. Same destination, different road. "Your Honor," I said, rising, "may I respond?" "Proceed." "Mr. Stafford is arguing simultaneously that I am mentally unfit to manage my own affairs and mentally sophisticated enough to orchestrate a complex multi-month legal entrapment of 2 adults and their attorney." I let that sit for a moment. "I'd ask the court to note that these positions are mutually exclusive. If I am incompetent, I cannot have planned this. If I planned this, I am manifestly competent. Mr. Stafford cannot have it both ways." Judge Calloway's expression remained neutral. "Mr. Stafford?" Stafford was ready for this. "The manipulation itself, Your Honor, demonstrates a pathological relationship with reality that—" "Or intelligence," Judge Calloway said quietly. She said it almost to herself, as though thinking aloud, and I saw Stafford's jaw tighten. "Your Honor," I said, "I have additional evidence I'd like to present." I reached into my handbag and removed the manila folder I had spent 3 weeks assembling. Harold Fitch had been quietly helpful once I explained what I needed. "These are financial records documenting every transaction between my late husband, myself, and the petitioners over the past 7 years. Loan agreements, transfer records, and bank statements." I set the folder on the clerk's table. $214,000, lent across 17 separate transactions. None of it repaid. Not $1. Stafford objected on discovery grounds. Judge Calloway overruled him with the measured patience of someone who has heard that argument before and found it wanting. Diane was looking at the folder. Brandon had stopped moving entirely. "This is not a family acting out of concern for an elderly woman," I said. "This is a family that has spent 7 years treating my husband's generosity as an entitlement and is now attempting to formalize that entitlement through the court system." Stafford called Diane to the stand. I understood the strategy. He needed to humanize the petitioners, to reintroduce the narrative of a worried daughter before I could do any more damage. Diane was composed when she took the oath. Back straight, voice steady, the capable professional face she wore to her finance job and her charity committees and every other arena where she needed to be taken seriously. She answered Stafford's questions about my behavior since George's death. The confusion, the apparent helplessness, the concerning signs. I let her finish. Then I stood up. "Diane," I didn't approach the stand. I stayed where I was, and I kept my voice exactly as it had always sounded to her. Her mother's voice. Nothing more. "Do you remember when you bought your first house? The townhouse in Alexandria, 2009? She looked at me warily. "Yes." "Do you remember who found the easement clause in the contract? The one that would have cost you $40,000 in access disputes within the first year?" A pause. You did. I sat at your kitchen table for 3 hours going through every page of that contract. You called me the next morning and said, "Mom, I don't know what I'd do without you." I watched her face. That was me, Diane, the woman who can't understand legal matters. Stafford objected. Judge Calloway allowed it. Do you remember who helped you negotiate the terms of your partnership agreement at the firm? Who spotted the non-compete clause that would have locked you out of your industry for 3 years if you'd ever wanted to leave? Diane's voice was quieter now. You did. I did. I held her eyes. In 30 years, you called me for help dozens of times. Legal questions, contract questions, situations where you needed someone who could think clearly under pressure. And every single time, I helped you. And every single time, you went back to thinking of me as just Mom. I paused. Do you genuinely believe I am mentally incompetent, Diane? Or do you believe that your father made a choice you didn't expect, and it was easier to call it incompetence than to call it what it actually was? The courtroom was very still. Stafford said something, an objection, I think, but it seemed to come from a distance, from outside the specific and fragile space that existed between my daughter and me in that moment. Diane looked at me for a long time. Her professional composure was still in place. Technically, her posture, her expression. But something behind her eyes had given way. I knew that look. I had seen it when she was 7 years old and had broken a neighbor's window with a baseball and was deciding whether to tell the truth. The exact moment of choosing. I don't know, she said finally. Her voice had gone very quiet. I don't know what I believe anymore. Stafford looked at his witness with the expression of a man watching his most important structure collapse from the inside. Brandon gripped the edge of the table, and somewhere in my chest, behind the discipline and the preparation and the 17 years of case law and everything George had built for me and everything I had built for myself, I felt the particular grief of being right about something you had desperately hoped to be wrong about. My daughter had needed me to be weak, and I had never been weak a day in my life. Judge Calloway called a 10-minute recess after Diane stepped down from the stand. I sat alone at the defendant's table and did not look at my daughter. I heard Brandon's voice behind me, low, urgent, stripped of its usual smoothness, and I heard Diane respond in something barely above a whisper, and I did not turn around. I looked at my yellow legal pad, at the notes I had made in George's study over 6 weeks of quiet evenings, building this case the way I had built every case before it. Methodically, patiently, 1 brick at a time. At the bottom of the last page, underlined twice, were 2 words, final evidence. When court reconvened, I waited until Stafford had finished his redirect, a brief, somewhat desperate attempt to rehabilitate Diane's testimony that succeeded primarily in reminding the courtroom of how badly it had gone the first time. Then I stood. Your Honor, I have one final piece of evidence I'd like to present. Stafford looked at me with the wariness of a man who has already been surprised twice and does not intend to be surprised a third time. Your Honor, any additional evidence at this stage, Mrs. Whitfield, Judge Calloway said, proceed. I reached into my handbag. The recorder was small. George had chosen well, as he always did. Compact, modern, the kind of device that looked like nothing in particular. I set it on the edge of the clerk's table and looked at Stafford. This recording was made in my home approximately 6 weeks ago, in my living room, during a conversation between my daughter and son-in-law. I was present in the adjacent room. I kept my voice level and factual. Under Massachusetts General Law, Chapter 272, Section 99, the Commonwealth requires the consent of at least one party to a conversation for recording to be lawful. As the homeowner present on the premises, I am that party. The recording is admissible. Stafford was on his feet. Your Honor, chain of custody, provenance. The device has not left my possession since the recording was made, I said. I can provide the original unedited file with full metadata intact, including timestamp and location data consistent with my home address. Judge Calloway looked at Stafford. I'll allow it. Mr. Stafford, you'll have the opportunity to challenge authenticity if you choose to do so after we've heard the content. Stafford sat down. His jaw was working. I pressed play. The recording had the slight ambient quality of a room, the faint hum of a refrigerator from the kitchen, the distant sound of a car passing outside. And then Brandon's voice. Unmistakable, with the particular confident energy he used when he believed he was only being heard by people who agreed with him. Stop overthinking it, Diane. The whole point is that it's airtight. Donovan's done this 40 times. Once the old woman is declared incompetent, we get the conservatorship. That's $58 million. We've been waiting 7 years for this. Don't go soft on me now. A pause. Diane's voice quieter, less certain. Brandon, she's my mother. She's an obstacle, and she's almost gone anyway. Another few years, maybe less. We just have to get through this part. The courtroom had the quality of a room from which all the air has been removed. I stopped the recording. At the plaintiff's table, Brandon had risen halfway out of his chair, his face a color I could only describe as the particular red of a man confronting his own voice saying the thing he most needed to deny. Stafford's hand was on his arm, pressing him back down. Donovan, who had been sitting slightly apart from the amended defense team, was looking at his own hands. And Diane. Diane was sitting very still. Not the composed, professional stillness she had worn all morning. Something else. The stillness of a person in the precise moment when the world reorganizes itself around a truth they can no longer avoid. She was not looking at Brandon. Judge Calloway's gavel came down once, clean and final. Order. Brandon found his voice. Your Honor, that recording was obtained under false... Mr. Hargrove. Judge Calloway's voice was not loud, but it had a quality that stopped sound. You are not currently a party speaking before this court. Please sit down. He sat. Mr. Stafford. Stafford stood, and I could see him assembling his response in real time, working with what he had left. Your Honor, Mrs. Whitfield clearly created the conditions for that conversation. She manufactured... She was in her own home, Judge Calloway said. Speak to the admissibility, Mr. Stafford, not the circumstances that led to it. The recording was staged. Mrs. Whitfield deliberately... Mr. Stafford. The judge set down her pen. Are you arguing that your client would not have made those statements under other circumstances? Because that is not an admissibility argument. That is a character argument. And I would strongly advise you to consider whether you want to continue making it. Stafford closed his mouth. I looked at Diane, because I could not help it. Because she was my daughter, and she was sitting in a courtroom hearing her husband call her mother an obstacle, and hearing herself almost push back, and hearing the exact moment she had not pushed back hard enough. Her eyes met mine. She didn't look away. Neither did I. Stafford made one more attempt. He was good enough to know the recording had damaged them critically, but experienced enough to reach for the only remaining thread. Your Honor, even granting the recording's admissibility, the conversation proves nothing about Mrs. Whitfield's competency. If anything, it demonstrates she has the capacity for elaborate, premeditated deception, which is itself a form of... Mr. Stafford. I stood. May I? Judge Calloway nodded. Your Honor, there is one more document I'd like to present to the court. Not as evidence of my competency, I believe that has been adequately established, but as evidence of the full truth of how this situation came to be. I reached into the handbag one last time. The envelope was worn at the edges. I had taken it out and held it many times over the past 6 months, in the evenings, in George's chair, when the house was quiet and the grief had its full weight. The paper inside was cream-colored, heavy stock, the kind George used for everything he considered important. The handwriting was his, small, precise, unhurried. I handed it to the court clerk. This is a letter written by my husband, George Whitfield, 14 months before his death. It was notarized by Harold Fitch in March of 2023 and filed simultaneously with his attorney's office and a sealed copy with the court clerk to be opened in the event of any legal challenge to his estate. I paused. My husband was a thorough man. Judge Calloway accepted the document from her clerk, read it in silence. The courtroom waited. I did not look at Stafford or Donovan. I looked at the window. February light, thin and pale, the kind of winter light that has traveled a long way to get here and doesn't have much warmth left in it. I thought about George maintaining that law cabinet for 17 years, ordering every new edition, filing every update, never once mentioning it, leaving the recorder in the drawer, writing Susan Calloway's number on a card, building, piece by careful piece, the architecture of my defense, not because he doubted me, but because he loved me. And love, as George had always understood it, was a practical thing. It showed up, it prepared. It made sure you had what you needed before you knew you needed it. Your Honor, I said, and my voice was steady, though it cost me something to make it so. My husband spent the last 2 years of his life building this, not because he thought I was incapable of defending myself. He knew exactly what I was capable of. He built it because he loved me, and because he wanted to make certain that whatever they threw at me, I would never have to face it without the right tools. I looked at the envelope in the judge's hands. In that letter, he documents his concerns about Brandon Hargrove's financial intentions. Specifically, he anticipated the conservatorship strategy with what I think you'll find is remarkable precision. He also documents the loans made to Diane and Brandon, the pattern of financial dependency, and his reasons for leaving his estate as he did. I paused. He wrote it 14 months before he died, when he was still healthy enough to be precise. He filed it with Harold Fitch and asked him to hold it. He told Harold, "If they go after Ellie, she'll need this." Judge Calloway finished reading, set the letter down. She was quiet for a moment. In that quiet, I heard the court reporter's keyboard, the faint sound of traffic outside, Tom Reardon shifting his weight near the door. Then she looked up, and in her eyes, careful, professional, controlled, I saw 35 years of knowing each other in the only way two people at law school truly know each other, watching each other think. "Mr. Stafford," she said, "do you have anything further?" Stafford looked at his notes, looked at Brandon, who was staring at the table, looked at Donovan, who gave the small, almost imperceptible shake of his head that means we're done. "No, Your Honor." "Mr. Donovan?" "No, Your Honor." Judge Susan Calloway set down her pen and looked at the room. It was the look I remembered from Georgetown, from moot court sessions where she had already decided and was simply organizing the precision with which she would say it. The look of someone who takes language seriously enough to choose each word on purpose. This court has reviewed all evidence presented today, including the petitioner's original filings, the financial records introduced by Mrs. Whitfield, the audio recording made on the petitioner's behalf, a pause, brief and pointed, and the notarized letter of Mr. George Whitfield, filed with this court's clerk office in March of 2023 in anticipation of exactly this proceeding. She looked at Brandon and Diane. The petition for determination of mental incapacity is denied. There is no credible evidence, medical, behavioral, or otherwise, that Mrs. Eleanor Whitfield lacks the capacity to manage her own affairs. The evidence presented suggests rather that she is one of the more capable individuals to appear before this court in recent memory. Brandon shifted in his seat. Furthermore, Judge Calloway's voice did not change in volume, but it carried a different quality now, the quality of something with weight behind it. This court finds that this petition was filed not out of genuine concern for Mrs. Whitfield's welfare, but as a mechanism to gain control of assets the petitioners believed they were entitled to. The recording entered into evidence today is particularly instructive in this regard. She looked directly at Brandon. "Mr. Hargrove, I've just listened to you describe your mother-in-law as an obstacle and state that you have been waiting 7 years for an opportunity to access her estate. I want you to understand clearly that this court has heard that recording and that I am referring it, along with the relevant financial records, to the District Attorney's Office for review under Massachusetts Elder Financial Abuse Statutes." The silence was absolute. Brandon's face had gone through several colors and arrived at something gray and fixed. The petition is dismissed in its entirety. The gavel came down. Court is adjourned. The room dissolved into motion around me, attorneys gathering papers, Stafford speaking urgently into his phone, Donovan quietly and efficiently packing his briefcase with the focused energy of a man erasing his own presence. Tom Reardon opened the gate and gave me a small nod as I passed through. Brandon walked out without looking at anyone. Not at Donovan, not at Stafford, not at Diane. Diane stood at the plaintiff's table, not moving, while the room emptied around her. When only the two of us remained, she crossed the courtroom slowly, not with the deliberate stride she'd walked in with that morning, but with something smaller, uncertain, like a person navigating unfamiliar ground. She stopped 2 feet away. "Mom." Her voice was a different thing than it had been all day, stripped of the performance of it. Just her voice, the way it had sounded when she was young. "I'm so sorry." I looked at my daughter, at George's stubborn jaw and my own eyes, and 38 years of a person I had chosen, every day, above everything else. "I know you are, sweetheart." She reached out and touched my arm, briefly, uncertain of her welcome. I let her. "I didn't..." She stopped, started again. I knew he wasn't. I knew Brandon was. But I kept telling myself it was also about you, that we were also worried about you. Part of you was, I said. I know that. Is that enough? I looked at her for a long time. Not yet, I said, but it's a place to start. She called that night at 9 o'clock. I was in George's armchair with a cup of tea going cold on the side table and a book open in my lap that I hadn't been reading. Mom, her voice was quieter than it had been even in the courtroom, younger. He's gone. I asked him to leave tonight. I closed the book. I heard him, she said. On that recording, I knew what he was. I think I've known for a long time, but hearing it in that room, in front of everyone, hearing him say she's almost gone anyway. She stopped. He was talking about my mother. Yes. Why didn't you tell me about being a lawyer? About all of it. A pause. All those years. I looked at George's photograph on the mantel, the sailboat, the Maine coast, both of us laughing. Because the day you were born, you were more important than any of it. I chose you, Diane, every single morning for 38 years. That wasn't a sacrifice. It was just the choice I wanted to make. I paused. But somewhere along the way, I let choosing you mean making myself smaller. I let you and everyone else believe that small was all I was. And that is something I should have fixed a long time ago. That's on me, too. A long silence. I borrowed all that money, Diane said. I kept telling myself it was different from what Brandon was planning. That Dad didn't mind. Your father minded, I said gently. He loved you too much to tell you. And I loved you too much to tell you. And neither of us did you any favors. She cried then, not the careful, deployed grief she had carried into the courtroom, but something real and messy and long overdue. I sat with the phone pressed to my ear and let her. When it quieted, I said, I love you, Diane. That is not a complicated thing. It has never been a complicated thing. Can we fix it? I think so, I said. But it has to be built differently than before, on honest ground this time, with you knowing who I actually am. I'd like that, she said. I think I'd really like that. After we hung up, I sat for a while in the dark and the quiet. The bird feeder was invisible outside the window, lost in the February night, but I knew it was there. George had hung it in exactly the right spot, sheltered from the wind, easy to see from the kitchen chair where I drank my morning coffee. He had thought of everything. I know, I thought. I know you did. 6 months later, I sold the house. It wasn't a sad decision. Or rather, it was the kind of sad that sits alongside something else, something lighter, the way late afternoon light is both fading and beautiful at the same time. George was in that house, but George was also in the law cabinet I had shipped to the cottage, and in the annotated case files I still couldn't bring myself to donate, and in the particular way I held my coffee cup with both hands on cold mornings, which was something he had always done, and which I had apparently been doing for so long it had become mine, too. The cottage was in Rockport, 40 miles north of Boston, on a rocky piece of coast where the Atlantic came in hard in November and quieted to something almost gentle in June. It was smaller than anything I had lived in since graduate school. I loved it immediately. Ruth Langley drove up the first weekend to inspect it, walking through every room with her arms crossed and her expression professional, as though she were a building inspector rather than a retired schoolteacher who had been my neighbor for 22 years. It's very small, Ellie. It's exactly the right size. The kitchen is sufficient. She sat down at the kitchen table and looked out at the water and was quiet for a moment. What happens now? I poured coffee. The good kind. The kind I'd been buying for years without ever quite letting myself consider a permanent indulgence, and sat across from her. I donated half of George's estate to the Georgetown Elder Justice Clinic, I said. It funds pro bono legal representation for elderly people facing exactly what I faced. Competency challenges, conservatorship petitions, financial abuse cases. I looked out at the water. Cases brought by people who don't have 17 years of law practice and a dead husband who spent 2 years building their defense. Ruth was quiet for a moment. And the other half? I wrapped both hands around my coffee cup. A comfortable retirement, I said, and possibly a book. Ruth looked at me. A book. About elder financial abuse law, accessible to non-lawyers, written for the people who need it. I paused. George always said I explained things clearly. Ruth's expression did something complicated, and then she laughed. A real laugh, sudden and warm, and reached across the table and covered my hand with hers. George, she said, was absolutely right. Diane calls on Sundays now. We are building something new. Not the old thing repaired, not a patched version of what we had before, but something different, constructed on a foundation of honesty, which is harder than the old foundation, but considerably more sound. We talk about real things. She tells me about the divorce proceedings, about the DA's investigation, about the slow, difficult work of understanding how she got to a courtroom trying to take her mother's life apart. I tell her about the book, about the clinic, about the morning walks along the rocky coast where the water comes in cold and clear and entirely without pretense. Last Sunday, she asked me something she had never asked before. Mom, what was it like, being a lawyer, before? I thought about it for a moment. About the yellow legal pads and the case files and the feeling of walking into a courtroom with everything prepared and knowing, in the particular way you know things after years of practice, exactly what was coming. It felt like thinking as fast as I could, I said, and finding out I was fast enough. A pause. You still are, Diane said. I looked out at the Atlantic, gray and vast and going all the way to the horizon. I know, I said. I finally know. Brandon Hargrove is currently under investigation by the Suffolk County District Attorney's Office. Derek Stafford declined further comment. Paul Donovan has not, to my knowledge, failed to research a defendant since. And me? I wake up every morning in a cottage by the ocean and drink good coffee and watch the water and work on a book that I think might help some people and read case law out of habit and wait for Sunday. They thought they were hunting a rabbit. They cornered a wolf. And the wolf, after 30 years of choosing to be something quieter, something softer, something that asked for help with streaming applications and got lost in road construction and kept her law license current in a drawer where no one thought to look, the wolf finally came home.